recognized to pick up where you left off.
Thank you. I'm not going to repeat my opening this morning. I don't know if we have the same people here or not, but I think I'll just turn it over to Mr. Pigeon, and he can complete his comments, and we'll go from there.
Madam Chair and members of the committee, I thank you for reconvening for this. I'm here discussing, my name is Stephen Pigeon. I'm here on behalf of the North American Law Center and discussing HB 1954, the Balance of Powers Act. And I'm testifying on behalf of the Act. And I just wanted to come before the committee here to highly recommend this Act. As I was pointing out before in the previous testimony, we are really starting to see where the rubber meets the road on this particular issue. This legislature just passed the voter ID bill, and that voter ID bill was just overridden by an executive order of Barack Obama, who has nationalized the elections, at least according to this executive order, that is going to allow him to establish a presidential commission for the administration of elections, to set up the polling booths, to determine the number of people that will be controlling it, etc. And so that provision most likely greatly exceeds federal authority and steps squarely on the state plenary powers. And so the question that really comes before the legislature is, what is the best tool to use in terms of enhancing the plenary powers of the state? And just for purposes of clarification, the state, in the scheme of federalism, has always had the ultimate decision-making authority when it comes to issues that are state governance issues. For instance, the state has its own criminal code, which is distinct from its neighbors. It has its own family law code. It has its own probate code. It has its own tax laws. And it varies from state to state. Some states have blue laws, and some states provide for common law marriage. Some states don't. But as you see, what's happening is that the federal government believes that one size fits all, and they simply do not have that kind of authority to overstep the plenary power of the state. And when the federal government does, and it hasn't been the inclination of the federal government per se to do this, although there has been incrementalism since the 14th Amendment on. And when they do this, the state has the responsibility to try to push back a little bit in order to make sure that the plenary power of the state is protected. How do you do that? Well, in one angle that you could do is you can allow private citizens to try to bring lawsuits to rein in federal abuses. Those are almost always unsuccessful because a common taxpayer does not have standing to bring such a thing. When it comes to, I can give you some examples. Oklahoma, for instance, passed a law that was rejecting Obamacare. And the Obama administration said they're just going to ignore it and they're going to force it on Oklahoma, period. Notwithstanding Oklahoma's law to the contrary. Tennessee last week did adopt their own form of this Balance of Powers Act, came out of committee and was passed by the legislature last week. And of course, Arkansas has a similar problem. You've just passed a Voter ID Act. How do you protect it? What the Balance of Powers Act does, it allows the legislature to form a committee who can review and hopefully expeditiously review any provision that happens from the federal government that appears to exceed federal authority. And when it does, the committee can come back and say, well, we believe that exceeds federal authority, and then recommend it back to the legislature, and the legislature would say, well, that's a clear encroachment on the plenary power. And if there is objection, like there would be in the case of how you're going to run your next election, the Balance of Powers Act provides that original jurisdiction for such an argument between the state of Arkansas and the federal government would be at the Supreme Court of the United States. That's a very important concept. It's provided for in the Constitution, and this bill just reinforces that. So when you first look at this bill appears kind of radical, but it really isn't. It's just kind of an assertion, if you will, of the state's common plenary power, and saying, all those rights that were not enumerated to the federal government are reserved to the states, and we're reserving them, and we intend to enforce those. And so this bill gives you a political infrastructure that you can use to go after that particular project. I'll be happy to take any questions on this particular matter.